Ednir Mutt in Kasaragod district, Kerala, traces its origins to Totakacharya, a disciple of Adi Shankaracharya, who founded it centuries ago as a center for Advaita Vedanta philosophy, spiritual learning, Bharatiya music, and Yakshagana folk theatre. Under Keshavananda Bharati, it managed vast lands for sustenance until Kerala's communist-led government's 1957 onward targeted such properties for reform, culminating in 1969 seizures that financially crippled the mutt. And the case arose when Kerala enacted land reform laws, including the Kerala Land Reforms Act of 1963, which was later amended in 1969 to redistribute property from religious institutions like mutts to tenants for socio-economic equity. Swami Keshavananda Bharati, as head of Ednir Mutt, challenged these in Kerala High Court in 1970 after the state sought to acquire excess mutt lands without adequate consultation, threatening its financial autonomy and religious management under Articles 25, 26, and 31. The dispute escalated to the Supreme Court amid broader tensions from Golaknath versus State of Punjab 1967, where the court curtailed Parliament's amendment powers over fundamental rights, prompting the 24th, 25th, and 29th Amendments to override it. Now let's examine Articles 25, 26, and 31 and their role in this case. Article 25 legally guarantees every person's freedom of conscience and the right to openly follow, practice, and share their religion. The state may impose reasonable limits for public order, health, morality, or other rights, but it can only regulate non religious, as that secular parts of religious activities, such as financial management. While Article 26 grants religious groups or denominations like mutts the legal right to manage their own religious matters, set up and run institutions for religious and charitable purposes, own and acquire property, and administer it according to their traditions. And Article 31, before its 1978 removal, legally protected the right to property. The state cannot forcibly take it without lawful authority and payment of fair compensation. It connects to Article 31A, which allows exceptions for land reform laws. Their direct link to the case, Kerala's Land Reforms Act aimed to take surplus lands from Ednir Mutt without full consultation or adequate payment. Swami Keshavananda legally contended Article 25. The land seizure harmed the mutt's ability to sustain essential religious practices through its income. Article 26. It violated the mutt's as a religious denomination legal authority to own, manage, and use property vital for its religious functions. Article 31. The state failed to provide fair compensation for the acquired property. Issues and arguments. Key issues included Parliament's unlimited amending power under Article 368 and validity of amendments shielding land reforms from judicial review. Petitioners Nani Palkhiwala argued amendments couldn't destroy basic constitutional features or rights. Respondents Hormasji Manekji Servai claimed absolute power for reforms. Petitioners led by N.A. Palkhiwala argued Parliament's amending power is limited. It cannot alter the Constitution's basic features or destroy fundamental rights, building on Golaknath case. The state, represented by H. M. Sirvai, contended Article 368 grants unlimited power for socio-economic reforms, and the Constitution is not basic in a way that restricts amendments. A 13-judge bench heard arguments over 68 days, and by a 7-6 majority, the court upheld Parliament's broad amending power under Article 368 but introduced the basic structure doctrine, which established that amendments cannot alter the Constitution's basic structure. It struck down the 25th Amendment's first part, excluding judicial review, but upheld the second and validated 24th and 29th Amendments. The Supreme Court delivered its monumental verdict on 24th April 1973 by a razor-thin 7-6 majority. While Keshavananda lost his land claims and the reform stood upheld, Parliament's amending power under Article 368 was affirmed but crucially restricted. The court declared amendments cannot destroy the Constitution's essential identity. This paved the way for the basic structure doctrine, which identifies untouchable constitutional features that no amendment can touch. This doctrine deems elements like supremacy of constitution, republican democracy, separation of powers, federalism, secularism, and judicial review as unamendable basic features. The doctrine has nullified over 50 amendments, for example, Minerva Mills in 1980 striking 42nd Amendment parts. It balanced parliamentary sovereignty with judicial protection of constitutional essentials and safeguarding democracy.